Hi, Charlie. It's good to see you again. How are you doing?
Nice to see you, Susan.
Good, good. Trust that maybe we can reach some resolution in the Peterson Denver case today. Trusting that we can maybe talk about possible settlement.
Well, my client has authorized me to come and listen in the hope that we can reach some sort of agreement. Obviously,
Sure.
I'll have to talk with my client about it afterwards, but I'm fairly certain that my client, he would accept any recommendation that I made. So, be happy to listen to any proposal you have to make.
Well, terrific. I think it would be useful at this point to review the facts a little bit here. And as you are aware, given our extensive conversations, my client, Ms. Peterson, who is a practicing patent attorney, was and is permanently paralyzed from the waist down as a result of being hit by the defendant in his automobile. The defendant's automobile, in fact, hit my client and resulted in her becoming a paraplegic. And needless to say, this has been pretty difficult for her. She has extensive medical expenses and also substantial lost earnings. The specials here are $25,000. And I think the other thing that we're going to need to factor in here is what her life looks like down the line. The reality is that she will probably have to have personal care attendants, perhaps an automobile equipped for her use, and there's a total revamping of her life that will have to occur, and this has even impacted her marriage quite substantially. Her husband has filed for dissolution of the marriage as a result, she believes, of her physical condition. So in light of that, you know that our complaint is for $5 million. And I frankly don't see going too far below that in looking at a settlement. I don't know what your thoughts are about that, but we can certainly chat some more about your perspectives.
Okay. Do you say you don't consider going too far below that? How far below that do you consider going?
Well, frankly, I think that we're probably looking realistically, given the extensive possible future medicals, at about $4 million, realistically.
Okay. Let me write that down because I don't want to forget that.
Sure.
All right, let me just characterize the facts as I understand them.
Sure.
So that we can maybe make sure as much as possible that we have the same facts, because obviously if we end up in trial, the facts are going to come out for our respective clients.
Without a doubt, sure.
The best that we can have them come out. It is true that your client has been injured, and it is true that my client was driving the car which collided with your client and resulted in the injury. However, the rest of it seems to me entirely unclear as to, first, how much my client as opposed to your client was at fault. It's my understanding that your client actually slipped and fell in the path of my client's car. So it's not as if she was, walking across the street within a legally confined crosswalk and he ran through the crosswalk and ran her down. That's not what happened. Also, and perhaps more importantly in this case, were it to go to trial, is the rather messy question as to what damages she would be entitled to beyond medical expenses and lost earnings. As I understand it, while she has suffered injury from this accident, it's also true that she continues to work at her profession, which is that of an attorney, and continues to make money just as well as she did before. So I have a hard time seeing that she's going to suffer any in terms of lost earnings in the future. As to the issue of her relationship with her husband, that seems to me to be the really messy part, because it's less than clear to me that whatever she's lost with her husband was that solid to begin with. Now, again, I don't know the information your client shared with you.
Sure.
It's my understanding that she was out, it was a social evening, and she was out rather late with a gentleman that she worked with, and we have not done any discovery yet, and that hasn't been gone into, but it certainly appears to me that the marriage that she had with her husband wasn't all that sound, perhaps, and perhaps she hasn't lost all that much. Now, we're sitting here in negotiation just between you and me talking
Sure.
about this, and we're not at a trial, but obviously if we were at a trial, all that would come out. So those are kind of the facts as I see them, and seeing them in that way, as I say, that leads me to believe that were we to end up at trial, it would be very messy business for both sides.
Right. Well, I agree with you that the goal here is that a trial should be avoided if it is at all possible. And it's obviously a little bit difficult because we've not had the opportunity to do a complete discovery, but our research does reveal that there is at least one possible, very reliable witness that would testify, we believe, that the defendant was speeding when he traveled up the hill, and that he also swerved sharply before actually striking Ms. Peterson. It also appears that he was attempting to avoid a car that was double parked, and it seems to me that under the circumstances, going up a steep portion of Powell Street on a Friday night, it was dark, in the rain, that greater precaution could have been taken on the part of your client to proceed with caution in approaching the cable car. The other issue, I think, with respect to the damages here, I think really the emphasis really should be placed on the fact that my client has, is in fact paralyzed from the waist down, which is obviously very traumatic. I mean, the impact on her life is just extraordinary, quite extreme. And the fact that she continues to practice her profession, I don't think really has that big of a bearing. And I think we would probably both agree that losing the lower part of your body is just unimaginable. And we don't know what the future holds for her. And she will, in fact, need to have a quality of care, not to mention unanticipated consequences as a result of the injury. So we are clearly looking at a substantial settlement here, I think. And what that number is, I mean, is certainly left up to further discussion, but I don't see this as an insubstantial settlement matter.
So, are you saying then that if you don't obtain the $4 million that you've just indicated here, that your client is prepared to go to trial and have all this come out at trial?
Well, I think there are a couple of things. I mean, my client clearly would like to avoid a trial. She wants this behind her.
Why is that?
Well, needless to say, she's already been through quite a substantial medical ordeal. In addition to that, she would like to continue practicing her profession and would simply not like to spend the time involved in trial with all of the possible testimony, unknown, coming out. I mean, that's just not, I think, a plausible way to address this matter. I think that there's another way to deal with it. At the same time, we have to be able to factor in what the future looks like for her, and that's simply what I'm attempting to do. So I'm not suggesting that we're locked in at $4 million, but you know, I've clearly indicated that I think something substantial is going to be required. Now, what that means, I think, is subject to discussion. As it relates to the actual liability, I mean, I think that the reality is, and I think the evidence would bear out, that the defendant is, in fact, liable here. And, you know, but for his actions, this accident and my client's subsequent paralysis would never have occurred.
Well, we're in a comparative negligence jurisdiction. You're not saying that my client's 100% liable, are you?
Well, it's hard to take a position otherwise, not knowing entirely the other circumstances. However, there is some evidence to suggest that my client may have slipped upon exiting the cable car. But the other perspective with respect to that is, did the defendant have an opportunity to avert the accident? For the purposes of discussion, if we assume that the defendant may be, or excuse me, that the plaintiff may be responsible in some way, I would say that that is not terribly significant. I mean, given the comparative negligence circumstance, and 10–15% at the most.
Okay, well, we're far apart there, because I would say it's at a minimum 50-50, and that's certainly the way I would approach it if was going to trial.
What's the basis for your 50-50 calculation?
Well, all my client was doing was driving his car, even if, as you say, he swerved to miss another automobile. That doesn't seem to be anything wrong with that. Your client would not have been injured had she been more careful and not slipped and fell from whatever it was she was riding on. I forget, the trolley,
it was a cable car that she was on.
The cable car.
Mm-hmm.
So there would have been no injury at all. So it's hard for me to see how my client could be more than 50% liable. I tell you what, well, go ahead.
I was just going to say, the flip side of that for me is just sort of understanding that your client is going up a hill, averts a doubly parked car, sees a trolley coming, a cable car coming, and wouldn't be more careful. So I somehow have difficulty with the 50-50 comparison. I would be willing to consider even a 70-30 option, but 50-50 under the circumstances just seems quite extreme to me. And
well, obviously, you would hope that you got a juror who would see it your way, and I would hope that I got a juror that would see it mine. And what we're trying to do here today, I guess, is avoid having the trial if we can. And maybe we're not going to be able to do that. Certainly, $4 million is way too high. My client, here's what my client would be willing to do in addition to the $250,000, which is a given in medical expenses and lost earnings, is $1 million on top of that. And if we can reach, if we can come to that as agreement, I can recommend to that client, to my client, and we can settle it today.
I'd like to consider a brief counter to that. You know, given the fact that I think we're a little bit apart on this comparative negligence issue. And I think that I'd like to counter that at $1.25 million, so above. So at this point, I think we're looking at $1.5 million if my calculation is correct. I don't know if that's something that you can take back to your client, but I think that that would be
$1.5 million?
right.
Okay. Now, are you saying, I mean, I feel like my client should have some, I mean, even if we go the 70-30 route in terms of the comparative fault, I feel like my client should have, there should be some recognition that my client wasn't totally at fault.
Well, I think the 30-70 accomplishes that goal.
Okay, so you think that at $1.5 million, we have accomplished the 70-30 goal? How about $1.25 million?
I will certainly take that to my client.
Okay, and I can recommend that to my client too.
Okay, thank
Okay?
you.
Thank you, Susan.